Are you involved in a painful family dispute or a fallout with a business partner? The information I'm sharing in today's session could make a complete difference from how your relationship will look on the other end of your dispute. This information is what most lawyers won't tell you about your right to completely shortcut the traditional system to get justice sooner, more affordably, and with higher odds of preserving your relationship. Are you ready to stop fighting and start loving again? What if I told you that the key to healing your broken relationship can be found at the intersection of law and love? I'm Judge Char, founder of Law for Love, and I restore justice to broken relationships through contract building, restructuring, and legal consulting that helps you convert conflict into connection that transforms your family, your community, and the world. Welcome, welcome, and what's the good word? I am excited about tonight's teaching and the possibilities that it unlocks in this environment that we are in. The entire nation is being shaken, right? And this is a good thing. While it's uncomfortable not having business as usual, by seeing all of the disruptions culturally, economically. These things are great because these are opportunities for us to pivot. These are opportunities for us to explore possibilities. And that is why I think this is a great time for me to bring you behind the scenes into the world of what I do, which is compassionate contract construction work, and why you should know this, your neighbors should know this, everyone in your community should be aware, because too many of us have been educated about our legal rights through TV, through courtroom dramas, and they're not telling us the whole story. So by the end of this presentation, you're going to understand what has gone wrong with the traditional legal system, why it's gone wrong, and how you can take power to make the system right. Like, you can actually exercise your power to make things right. What is the best way to address an offense between you and a loved one or a business partner after you've had a falling out? Well, most people would agree that trying to talk things out would be the first thing that you do. What we do know about human nature and human relationships is that the conversation doesn't always go that way. In our human nature, if I feel that you did me wrong, I think I'm right. Or if you think that I did you wrong, you believe that you are right. And when you have two different sides with this very, very strong disposition, like you did me wrong, and there's no getting past that, then the justice system is necessary to get involved to help bring justice. Justice is about recognizing that a relationship has been harmed, recognizing that a wrong has been done, and finding a way to make it right. Excuse me. I just had the dinner of champions, some plantain chips and kombucha real quick before the show. So some people can figure it out talking amongst themselves. Some people can figure it out with a little bit of help within close proximity. But what we see in the legal system is when everything else before going into court has not worked. And that is why people are seeking justice through the legal system. So traditional litigation can often be nasty, and I want to show you the reasons what leads up to the nastiness, and it leaves people even more bitter and exhausted and pockets hurting after this process. And nasty court cases are more painful than the original issue that caused the conflict in the very first place. which is why compassionate contract construction is such an important way to avoid all of that. And in informing and empowering you as the listener, as the public, as the community to understand exactly how to shortcut the traditional legal system is a key to us making a lasting change for ourselves, for our families, and for our communities. So, alternative dispute resolution, or ADR, is the most effective way to end the pain and these issues concerning disputes, especially between people with close relationships, whether it's family, whether you went into business with a very, very close and dear friend. Alternative dispute resolution is the term that we use in the legal system. It's not talked about enough in public spaces. Most people in the public are not familiar with ADR. And so that is the big umbrella of what I'm discussing today in terms of the best way to deal with your disputes. And I'm going to reveal all of those details in just a few moments. But first, I want to introduce myself and tell you a little bit more about who I am and why I decided to do justice differently. So, I'm Judge Char. I am a certified arbitrator and licensed attorney. And my government name, right, Sherlyn Char Selassie. So, from the standpoint of public access to information about me, my professional background, this is the name that you can totally Google me and find out more about who I am, how I practice, and what other people's experience has been working with me as a professional in my work. I am the founder of Law for Love. And here at Law for Love, our practice is involved in love, legacy, and leadership. So we work in the relationship space. We help individuals, families, and businesses think about and plan their legacy through estate planning and succession planning. And we also help and support leaders in equipping and training in the very style of work that I do and that I've been doing since 2020, when I went into private practice and decided that I wanted to do something very, very different than what I was taught to do in law school. Because what was happening was that I was in a law firm that required me to take cases for litigation. There was no option of providing alternative dispute resolution. As often as I could, I would organically change cases from a litigation type of case into a mediation type of case, because I have what my colleagues began to recognize as settlement mojo, a way of getting in, jumping into the middle of a food fight, understanding what's really happening, the underlying causes of the conflict, and helping people find common ground and to find a path to restore and rebuild their connection and their relationship. I am very much so a relationship oriented professional, very much so an oddball. When you think of lawyers or legal professionals, you typically think of pit bull in the skirt. You typically think of tough and grimy. I never was that person. I never could be that person, which was why what I'm going to share with you about litigation was just not that was not the world for me, and have been able to make so much more of an impact in the lives of the families that I serve through alternative dispute resolution in my private work as an arbitrator and a mediator. So what makes the system that it is now, and all of the stuff that's wrong with it and all of the reasons why, like, can I say this for a minute? Like, I found myself more often than not being embarrassed to be associated with other lawyers. Like, all of the lawyer jokes and all of the things that people say and think about lawyers, that's just not who I am. Like, I don't even like being associated with it. And I've worked really, really hard since 2020 to distinguish myself from other lawyers, because there's this cultural understanding of lawyers, and there's this culture within the practice of law that's not very relationship oriented when it comes to our clients. It's not very compassionate when it comes to our clients. Compassion will get you killed in the culture of the current legal system. And it's this attitude, and it's the lawyers that really has developed the system and structured the system into what it is now. It is what I describe as the belly of the beast. And the more that I've saw people who used to love each other come out of the system hating each other, the more I saw it as a meat grinder, the more I saw it as a force for destruction and not for justice, the more I saw it as an opportunity for lawyers to be opportunistic and to make as much money as possible by keeping conflict going between people. And I just didn't want to have anything to do with that. And so, yes, I don't appreciate lawyer jokes because not all lawyers are like the lawyers that you hear about. There are a lot of attorneys like myself who we actually love our clients. We actually hug our clients. We actually pray and are concerned about our clients. We actually hold our clients close to our heart and we're concerned about their welfare. But that's not the majority of lawyers. And the majority of lawyers, this justice is a business. It's not about justice, and it's not about reconciling relationships. So in order to understand what the system is, how it is, and why the compassionate contract construction is so different than the traditional approach, you need to know your lawyer. So I'm going to share with you who the three main type of lawyers who are in the system and who are practicing in the system and who are driving the system. And you are going to kind of get an aha moment when I break this down, who each of these lawyers are: the litigator, the mediator, and the negotiator. And the traditional system is what I call a lawsuit first dispute process. And this is the litigator's game. Now, the litigator is a lawyer that you see on the TV, the courtroom attorney. Hold on just a second. The litigator is your courtroom lawyer. This is who everyone thinks lawyers are, right? The assumption, if you are on the outside of the legal system, you're not an attorney, when you think lawyer, this is typically the person that you're thinking of, and we refer to them as litigators. Now, the litigator this is the group of lawyers known as trial lawyers. They do their best work in court. And in court, it's about being ready to fight, right? They are prepared to punish the other side, and they are focused on winning. They rather argue than negotiate. And just to let you know, negotiation requires patience. Litigators are not known for being patient. They are known for scrapping. They are usually very, very focused on the details of the trial, and they're not thinking about how the destruction of the trial is going to impact the relationship after the trial, because they want to win. This is a contest. This is a battlefield. This is about somebody has to leave alive after killing somebody else. That's the preoccupation of a litigator. Their focus is on procedure and not relationship. So it is very important for you to understand who a litigator is. If you are dealing with maybe like one of those large corporate class action type suits, then yeah, you want a litigator, because you're not interested in having a relationship with the corporation that sold you baby powder that created cervical cancer. You don't care about your relationship with that company or that corporation. But when you're dealing with, what I call arm's length relationship, it's not me as an individual against you as a big corporation. It's me as a family member against you as a family member. It's me as a small business owner against you as a small business owner. Those are the spaces that are more relationship oriented. And litigators don't care about the relationship. They care about winning. They are good in certain situations. So it may sound like I'm saying litigators are all bad. No, they're not. If you're dealing with an extreme imbalance of power, again, an individual consumer versus a large corporation, or someone has committed a crime or fraud, then you definitely want the pit bull in the skirt. You definitely want the tough guy in the courtroom. You want this person who is a complete jerk and doesn't care about any kind of relationship and only wants to win because of these type of elements. And I will confess that my most enjoyable work as a litigator, which is what I did for the first 9 years of my practice, I loved litigating against used car dealers. Again, it had the David and Goliath feel to it. I often represented single moms who used their tax returns to buy a car that broke down as soon as they drove it off the lot. Those were great cases to go in and let have and be a real pit bull on behalf of my client. So litigation is a wonderful, wonderful style of legal practice when you're dealing with extreme imbalance of power or crime or fraud. So litigators, in terms of the relationship that most people experience when they work with a litigator, the litigator's attitude is like, because I said so. A litigator is not necessarily really trying to educate you about the process. They're aggressive, they're argumentative. They want you to let them do their job. They're not explaining what you can expect next. They're not holding your hand. They don't want to hear you cry. They don't care about your feelings. They just don't. And it's hilarious because I've worked with several litigators, and this is their disposition. They're great people outside of the profession, wonderful people to have lunch with and to get to know. But when it comes to their work, they are very, very focused on winning a trial and they don't have time for the warm and fuzzies. They just don't. And a lot of people are fall out with this litigator type style of an attorney. They feel like the attorney is too aggressive, or the attorney doesn't listen to them, or the attorney doesn't return their phone calls, or is mean or short with them or cuts them off. That's typical of a litigator relationship with their client. And so again, the lawsuit first method, this is the traditional system. The first thing that happens is a lawsuit. Y'all, this is how we were taught in law school. We were taught in law school that when someone has a dispute, go ahead and just start preparing a lawsuit. Go ahead and file it. It begins with a lawsuit. And this creates anxiety. Getting served with some papers. You just got home from work and you're preparing to have your dinner, and you get a knock at the door and you've been served. This is just the wrong way to start attempting to resolve a dispute. And what do people do when they get served with papers? They go and call a lawyer. They contact their closest friends. What should I do? I got served with papers. Hey, you need to get a lawyer. So now everybody gets lawyered up. And the incredible thing about getting lawyered up, you don't know who the other person's attorney is. And the combination of attorneys can create a real interesting outcome in a person's case if you just get the wrong two people who are overly aggressive, two people who don't have any kind of chemistry or human connection, two people who find every opportunity to fight. They are going to destroy the atmosphere of your relationship with the other party and any hopes of y'all reconciling your differences, because the lawyers can't even get along. And it increases defensiveness. You and the other person who used to be able to have a cordial conversation, who used to be able to exchange text messages for important information, you go from speaking with each other directly to saying, talk to my lawyer. Why? Why are you unable to talk to each other now? Because the culture of the litigator is now driving and fueling anxiety and defensiveness, and you being hyper vigilant about protecting yourself, because that's that spirit that the litigator brought into your dispute. The second step in a lawsuit first dispute is the discovery process. And this is an extensive and time-consuming process. You have a right to get all kind of information. And this is where most people find that their legal expenses skyrocket. They really run away. And most litigators are going to ask burdensome and irrelevant questions and ask for stuff from 10 years ago, like they're going to make you miserable when you get these requests. It's going to take you the entire 30 days that you may have to respond to this kind of request, to dig up records and to answer questions. And it's extremely, extremely frustrating for the parties. And this is actually a trial strategy. It is a technique to dominate you, to oppress you, to drive up your legal expenses, to make you cringe and want to come to the table and just give up. It makes absolutely no sense from a relationship preservation standpoint. And again, increases the defensiveness and hostility in each side. I can't tell you how many times I've gone through discovery responses with clients and they feel personally attacked by questions that are oftentimes routine questions that anybody would have a right to ask. You have a right to ask the same questions, but you feel defensive that you have to answer these questions. And this is the place in the in the lawsuit where even a lot of clients and their attorneys fall out because of the amount of time that it's taking, the amount of hostility you're feeling, having to answer all these questions and dig up all these records. And when you start getting that invoice, you start getting that bill from your lawyer for all of their hours, right? We're talking about, for me, I'm $425 an hour in the litigation space. You get a bill where after I've had to spend 15 to 20 hours working on your discovery, you are going to be upset. And a lot of people fall out with their attorneys because of all of these emotions and all of the costs in step 2. And step 3 is mediation. And this is where a judge tells everybody, okay, now y'all need to go sit down and talk. And now you're forced, each side, to participate because the judge told you to do it. And typically the lawyers choose the third party neutral. That mediator is oftentimes, at least here in Georgia, oftentimes an attorney as well. And I'll tell you this also, because it's court ordered, oftentimes it's connected to the attorneys that are listed with the court's list of mediators. And in many counties, only attorneys can serve as the mediators. And y'all, I can't tell you how many people I've met who are awesome at the practice of mediation, who are not lawyers, who have been shut out of the court system because it's on lock with lawyers. Lawyers have a monopoly on the court ordered mediation, even though non-lawyer mediators can mediate. Each side presents their information and their request to the mediator. And again, you're forced to participate. But whether or not you settle is 100% voluntary. Most cases settle in mediation. If I had to put a percentage on the cases that settle in mediation, I would estimate anywhere from 85 to 90% of cases that begin with a lawsuit actually end with litigation. End with mediation. The mediation process itself is somewhere between 4 to 8 hours, typically. Sometimes it could take a day or two to get through all of the issues, depending on the complexity of the situation. And that would be in the more difficult cases that would need maybe a second half day or a full day to get through all of the issues. But 85% to 90% of cases settle this way. So step number 4, in the traditional lawsuit first dispute process, or the traditional process we all see on TV, is trial. Now, trial is unfortunate. This is where you end up when you could not settle your case through mediation. Your attorneys could not get along well enough to figure this thing out in a way that makes sense for you. And it's open to the public. Anybody can come and walk off the street and sit down in your courtroom and listen to, the dirty details and the intimate details of your life, and you airing out all your dirty laundry and letting all the skeletons out the closet. There are typically multiple cases scheduled at the same time as yours. So think about the doctor's office, right? You're not the only person who was scheduled for a 9 o'clock doctor's appointment. It's 2 or 3 other people scheduled for 9 o'clock. That's how the court schedules cases, because there's so many of them. In fact, COVID created so many backlogs that have seriously delayed trials. And so It's not uncommon now for a trial to be delayed 18 months, 2 years. For really complex cases, maybe you might get a trial in 3 years. Again, a public display of the intimate details of your life and all kind of stuff that comes up in these disputes, right? Your internet habits. Like, think about what you're doing on the incognito browser that you might not want the whole public to be able to hear about. Your phone records, your bank statements, other nasty and embarrassing details of heated conversations that y'all have had while this relationship has been deteriorating. All of it is open up for the public to be in your business. So that's step number 4. And my question is always is, if 85 to 90% of cases are resolved through mediation, why not just start with mediation? This is the question that you as the public should be asking. This is the question that legal professionals should be answering and delivering opportunities for the public. If 85 to 90% of cases are settling that way, why not start at the place where cases are settling anyway? I mean, it would just make sense, right? So let me tell you what happened to Carrie when she hired me. She fired her litigator. She was involved in a custody dispute with her ex-husband and hired this large, reputable law firm to represent her. And she and her ex, they didn't have the best communication, but they both really, really loved their child. And the thing that really kind of like pushed her over the edge because of the emotions that were driving this case was that every time she called her lawyer, she was being invoiced $55. Phone calls that were 10 minutes long, 15 minutes long were costing her $55. Like, she lost it. And she was like, you know what? I can't do this anymore. So she found me. And although I typically don't get involved in active litigation during that season in my practice, there were some exceptions that I would make based on my heartstrings. I'm a softie, right? And this involved a child, a very special child, two parents that really, really loved him. And I wanted to get involved in getting a good outcome for this child. So we ended up having 3 attorneys in this case because the child was also represented by an attorney. Let me tell you, when this client came to me, she had already invested more than $33,000 in her representation, and they were only at the discovery stage when I was hired. Excuse me. We attempted mediation, we attempted informal negotiation. There was a lot of difficulty here. And again, because these people were becoming more and more defensive and becoming more and more hostile, in part because of the expense. The expense was creating nastiness in their communication. Every time they got an invoice from the litigators, it was like, I don't even want to talk to you. I'm only going to deal with you through the lawyer. I'm paying for the lawyer. Let the lawyer deal with it. We were scheduled for trial, and the day of trial ended up settling the case without having to go in front of the judge. We were able to announce that we had worked it out for this family. Once again, not needing a trial, but I firmly believe, had another process been the way that this dispute started, my client would have saved close to $30,000 in legal fees, a ton of anxiety and frustration with the ex. The child would have not been subjected to the hostility and the frustration that the parents were feeling. In this case took, I want to say it took us about 18 months from the time the case was filed until there was a trial. We could have had this case resolved for this family anywhere within 6 to 9 months instead of 18 months. That is my honest belief. Had they not started with a lawsuit in this case, only to settle, y'all. So that is my question. What would have happened if Carrie had not begun this dispute with a lawsuit?
Let me introduce you to the deal maker.
Hold on just a second. So the
in my experience,
give me a second.
best family law outcomes
Okay, so here I'm introducing you to who the other two types of attorneys, I call them the deal makers. That's the mediator and that's the negotiator. Now they're very, very similar. These are the folks that are not necessarily getting their cases finished out in trial. They're communicating with one another. They're communicating with the parties. They're figuring out how can we make this right by talking to each other. And so the mediators and negotiators are similar because they're knowledgeable of the law and how it applies to the facts of the case. They know how to make the law work and explain the law to the clients. They are relationship oriented. This is the big one, relationship oriented. Even if you're dealing with someone who may not necessarily be emotionally tied to their client, they attorneys who are mediators and negotiators typically work really well with other attorneys, are quick to pick up the phone or shoot over an email and have a discussion. There's a lot of conversation happening in the background of a case, a lot of conversations happening in the background of a case. And these are the relationships that are driving those conversations and helping families to get a resolution or helping the parties to get a resolution without having to go to trial. So they're focused on finding a win-win, and they're very skilled in making deals by educating their clients. Unlike the litigator, these two types of attorneys will explain things to their clients to help them make decisions about what they're willing to give and what they want to take out of the dispute. And they typically see the bigger picture and the long-term solutions that are extremely important for the relationship. Now, the difference between the mediator and the negotiator is that the mediator is more wired for fairness for both sides. The mediator naturally sees both sides. The mediator naturally sees how each side might perceive the situation. Whereas a negotiator is usually more focused on the best deal for their client rather than seeing how both people feel in the situation. So that's the primary difference between a mediator and a negotiator. Negotiators, I like to think of, the guys who are showing up in court and they're just ready to hurry up and do a deal, and the art of the deal kind of thing. Let me get the best deal for my client. But they're still very relationship oriented and they do great work. They're just not wired the same way as mediators who naturally see both sides. Mediators are wired for fairness, and fairness isn't always 50-50. And so good mediators are typically super creative for finding common ground that's going to make both people feel heard, respected, and understood, that both people are going to feel like this outcome makes sense and that it's fair, even though it may not necessarily be a 50-50 kind of deal. And they hate the litigation system because mediation is just better. It just is. If 85 to 90% of your cases are settling through mediation, does that not tell you that mediation is better? And fairness, this thing is advancing on its own. Is trying my patience. um, Fairness is the same quality that mediators have with some of the best judges that exist in the system. Great judges are fair, and mediators have that exact same wiring to be fair. Mediation is a gift, and it is a unique skill set for understanding the law and truly hearing both sides, which is how justice happens. Justice happens where people feel heard. Justice happens when people feel understood. Justice happens when people are given their options in a way that's respectful and where they're empowered to make choices. And this is the gift that mediators are to the system. And that's why compassionate contract construction Our process is a super duper unique 5-step system where we use this same exact beauty and gift of mediation, sometimes combined with arbitration, just depending on what the situation needs, where we begin with a conversation. We don't come out the gate filing lawsuits. And we help people exchange the information that's necessary, not sending people this expensive, burdensome list of send me the last 10 years of your legal record stuff. We don't do that. And we facilitate conversations that help find common ground where both sides can agree how they can move forward. We also, the key recipe to compassion here is identifying opportunities to heal and mend misunderstandings that have brought people into broken relationship with one another. I cannot tell you how many times I've worked with two sides who are fighting, and all I hear is how much they love each other. They're unable to talk to each other because of the pain of what's happened between them, but they love each other. And being in a position where I get to, as the person in the middle, as the neutral, I get to pass love notes back and forth. We literally are delivering healing and reconciliation just by conducting conversations where people are able to be honest and safe. And then we write up the agreement, whatever the agreement is, and we have it witnessed, and it's 100% legally binding. This is the contract. The contract is the agreement that's been designed by the two people who are able to use the assistance of the compassionate interpreter. That's what the compassionate contract constructor is: an interpreter, a person who can interpret not only what's hurting you, but also what you desire. Well, not only that you are frustrated, but what you would love to see this relationship become, and figure out how can y'all make this work together. Passing love notes and helping you see each other beyond the dispute and see each other for the love and the things that brought you into relationship in the first place. That's what we do. And again, contract law is about two or more people who have a meeting of the minds and an exchange of value, which is called consideration in law. Most relationship breakdowns happen in the meeting of the minds area. There has been a misunderstanding. There may have been some yelling, some screaming, some posturing. There may have been some threats. But as the compassionate mediator, we are the healers of the legal system. We are the ones who are looking at what you have to lose if you deal with your conflict the wrong way, if you don't take advantage of the better way, leaving the lawsuit out first and having the conversation first. Because 85 to 90% of the time, this is how you would settle your dispute anyway in the legal system. And that's why most lawyers don't want you to know that, because it's very, very lucrative to drive your conflict into the point where you have spent all of your money. I don't know if you know, like if you could ever remember purchasing a car, how exhausted you feel at the end of a used car purchase or a new car purchase, all of the paperwork to be done, all of the negotiating, all of the back and forth and the haggling. That is what how a lot of people end up mediating and solving their case at the end. After doing all of the exhausting work and the expensive litigation, it makes absolutely no sense. And this is why Law for Love has been so successful in bringing people into the legal system the opposite way, without the lawsuit first, with the conversation first, because the folks that we work with love each other. We had this amazing case with some co-parents. We were contacted by a young mom and very, very vigilant about co-parenting with the father of her child. They had a beautiful child together. They had been doing a really, really great job working things out outside of court, and had some multiple co-parenting attempts to really kind of get in a place where they can maintain peace with one another while raising an amazing young person. But at this point, Dad decided that he wanted to have his legal rights observed. It's a really big deal here in Georgia because fathers of children born outside of wedlock are not legally recognized as the father unless they get a court order. And mom wanted things to be fair in terms of their financial obligations and certain things that she thought were best for the child. And so mom reached out, got me involved. I reached out to dad. Dad was, and again, these were young parents, but they were so forward thinking about the fact that they had to have a workable relationship with each other to raise this child with as little drama as possible. So dad was 100% on board with working with me as the mediator, and we were able to maintain the benefit to the child of having her dad legally recognized as her dad with mom's consent. No need to go into court and fight over anything. No need to file papers and serve mom. No need to go through all of the rack'em scrack'em of the traditional process. We worked everything out in a mediation process unique to the way that we work with our clients to get these parents on the same page and to kind of air out some stuff that was getting in the way. And I absolutely commend them because, again, they are younger people, adulting and having to figure out how to co-parent and navigate some legal stuff. And they had the foresight and the wisdom to hire a mediator. And so my hat goes off to them for the incredible work that they did to keep drama out of their co-parenting relationship. And so how compassionate contract construction makes the difference. It provides safety. I always invite people when we're having our process, meet with you one-on-one, be completely safe to say what you need to say. Get it off your chest. Say it with your chest. I need you to be 100% honest with me so that I can filter out the stuff that would trigger the other person, because again, I'm the interpreter. I need to hear what you're feeling and what you're saying so that I can repackage it and come to the other person and find where y'all can have some common ground. And that's where the compassion really comes in, because if you're over here and having an honest conversation with me and feel safe to talk to me, and you really just want to kind of curse them out in a rant, well, I'm not going to tell you that you're wrong for feeling that way. I'm going to let you get that off your chest, and we're going to unpack it, and then we're going to figure out what do you really want out of the situation, and how do you want me to approach the other person about the situation. And really just feeling the root of the pain and going back and forth between them is how we make the difference. Just really letting people be themselves and live and speak in what they're seeing is true, and finding out where the misunderstanding is, and communicating it in a way that's not threatening and that's respectful of both of these people and their desire to move forward without making things worse. We also had another family. They already knew how the game works because they went through one of those 6-figure, expensive, lawyered up divorces. And they had to learn through experience that they did not want to go back through the expense of the 2-lawyer traditional legal process to change custody when the teenager decided that she no longer wanted to live with mom. She wanted to live with dad. Both parents were aware that she was old enough to make that decision. Both parents were agreed that the child was making a good decision. It wasn't a decision that was harmful to her. And they just did not want the drama of lawyering up. And by utilizing us as the mediator, we were able to get all of the changes necessary documented. Everyone signed off on it, and a complete change of custody. And no one even stepped foot in the courtroom because it was not necessary to start with a lawsuit, getting people served, and creating the drama of combat is what I call litigation. It was totally unnecessary. In this family, we had them taken care of in about 3 months from beginning to end. Every relationship is going to be tested with conflict. This is life. And conflict is the pathway to deeper connection. I've had to learn that personally, and am definitely here to encourage anyone who's experiencing conflict, whether it be a family relationship or a business relationship. getting through it and getting through it with the right kind of support and the right type of professional makes all the difference in how you may preserve your relationship on the other side. And that's why I want to complete this presentation with a story about collateral damage. This is a cautionary tale. Nasty contested custody divorce involving several children. And after the divorce, which was 2 years of fighting, the fighting continued after the courtroom drama. They never figured it out for the kids. And 10 years after we completed this case, I received a phone call from my former client looking to hire me to go back into court for rada rada, yada yada yada. All kinds of, we're not done fighting yet. 10 years later, we're not done fighting. And the former client broke my heart when she told me that the oldest child had developed severe mental illness as a result of the stress of these parents fighting. And what was even more sad to me was that mom wasn't even seeing her role in it. She wanted to keep blaming the ex. He did, he did, he did, he did. But at the end of the day, this child needed someone to see the future of the relationship beyond court, needed someone to have the maturity and the sense not to destroy him with all of the endless stress, strife, fighting, and courtroom dramas. It makes no sense. So, for those of you who were wondering what is compassionate contract construction, I hope that this explanation of how the system works and how we kind of do it completely in the opposite order. I hope that this makes sense to help you understand what it is when we talk about compassionate contract construction, what it means, how we're doing it, why we're doing it. Because when my client came to me several years ago, and all of what they needed legally had been taken care of by the religious leader at their temple where they worship, it was a game changer for me. Like, I'm sitting over here, I'm supposed to be the one that knows everything about the legal system, right? I'm supposed to be the one that knows everything about family law. No, this community had enough sense to support this family by getting an agreement done outside of court. So by the time the lawyer got involved, it was just about taking care of the formalities. That's called wisdom, y'all. And that's what compassionate contract construction is about, helping people find that meeting of the minds that's going to preserve their relationship. Because people, we all hurt, we all want to love, we all want to feel understood. Sometimes misunderstandings happen, but do we throw the whole relationship away because of a misunderstanding? If a relationship can be preserved and should be preserved because or by a simple conversation, why not? So that's what I'm on, and I hope that this helps you to know more about the legal system. I hope that this empowers you to educate other people in your community about what's wrong with the legal system, and gives you, some equipment to be able to articulate why. I don't know, maybe you should call a mediator first. Like, why don't we start making that the advice that we give people, rather than someone coming to you and saying, hey, I'm having this problem with this person, rather than saying you should call a lawyer first. Why not, let's start advising people, why don't you call a mediator and see if they can help? Can you see how we could be saving some dignity, how we can be saving some expense, how we could be saving some frustration, just by changing the way that we give people advice when they have a falling out? I hope that makes sense. I appreciate your support of this channel and look forward. Oh, next Tuesday I'll be live for trial. My birthday trial has been rescheduled for next Tuesday morning. So I will be going live next Tuesday morning. Um, I'll probably be doing the Monday night as well, because I'm pretty much where I need to be prepared for trial. But I'll be live as well, taking y'all through my very last trial on this side of the dispute, as the attorney representing the respondent. So join me for that, because again, it's behind the scenes. What's wrong with the system? Why you don't want to go running up in the system? Why you don't want to be giving all your money to lawyers? Like, yes, I'm spilling the tea because we need to do a better job as professionals. We need to be helping people get to resolution faster, which is not as lucrative for us. But why are we dragging stuff out when people are hurting like this? And people are in and out of court, in and out of court, in and out of court, because of the nature of the beast. Involved in a painful family dispute.
Always remember this: the destination is love, and the journey is love. And it is love that conquers all fear and transforms our world. Hey, if you were blessed by this content, please like it, share it, and subscribe. Follow us on social media at Law for Love ATL. And we bless you and thank you for all of your support.